We have two cases on our oral argument calendar this morning. Rochelle Cox in her official capacity as interim superintendent of the Minneapolis Public Schools versus Clapp, and Great Northwest Insurance Company versus Campbell. We'll take Cox versus Clapp first. The record should reflect, here, you're good. The record should reflect that Justice Galletas is recused on this case and will not take part in any way in the deliberation or consideration of the case. Just a reminder to counsel that you'll each have 3 minutes of uninterrupted time to make whatever opening statements you'd care to make to the court. At the end of those 3 minutes, if you have not stopped yourselves, I will stop you to see if the court has any questions. Mr. Sullivan, it looks like you've reserved 3 minutes for rebuttal. Is that correct?
Yes, ma'am.
All righty. You may begin when you're ready to do so.
May it please the court. Good morning, Your Honors. My name is Tim Sullivan, and I am here this morning on behalf of the appellants, Minneapolis Public Schools and Rochelle Cox. This case is about when a mere taxpayer should be permitted to insert themselves into a collective bargaining agreement that's been duly negotiated and entered into between a public school board and an exclusive representative of teachers. Here we have Minneapolis Public Schools, represented by its elected school board members, and the Minneapolis Federation of Teachers, which represents 2,000 teachers that work for the Minneapolis School District. The claim here involves a single provision of the teachers' collective bargaining agreement that pertains to layoffs. The claimant is not a party to the contract. She is a taxpayer. In most cases, standing requires the claimant to set forth an injury in fact that is unique to them. Here, Ms. Clapp admits that she suffered no such injury, but rather asserts she's entitled to challenge this provision of the contract under the taxpayer standing doctrine. This is a limited exception to the general rules of standing, and it's somewhat of a legal oddity, as courts are designed to resolve disputes involving actual grievances between adversarial parties, not to serve as platforms for ideological or policy-based disagreements. Without clear outer limits, the taxpayer standing doctrine invites challenges that may stem from political or philosophical motivations rather than genuine concerns about misappropriation of public funds. Now, this is not the only taxpayer standing case that this court will hear this year. In fact, you recently decided the Minnesota Voters Alliance versus Hunt case, where this court held that taxpayer standing only exists when there's a claimed unlawful expenditure of funds, and that expenditure is central to, not incidental to, the claim being asserted. So in other words, this court expressly held that when standing otherwise does not exist, a claimant cannot manufacture it by merely pointing to expenditures that are incidental to the claims. This holding makes sense given the underlying purpose of the taxpayer standing doctrine, which is to recognize that taxpayers have an interest in their tax money not being spent in a manner that is illegal, in a manner that would reduce or increase the overall tax burden. Ms. Clapp's claim to standing in this case fails under Hunt, as the central issue of her claims is unrelated and not centrally related to the expenditure of funds. Any claimed disbursements at issue in this case are operating expenses that would be incurred regardless and therefore are at best incidental. So today we respectfully ask this court, consistent with Hunt, to expressly hold that merely asserting that some money will be spent that is just general operating expenses is insufficient to establish taxpayer standing, as such expenses are by definition incidental rather than central. There are a number of limitations on the taxpayer standing doctrine that this court has put in. That was my 3 minutes. If you'd like to field questions, I'm willing to start with that as well. All right.
Well, I'll jump in. So my first question does relate to MVA v. Hunt, and your brief is arguing that we need to find a specific and unlawful disbursement under McKee. Does our opinion in MVA sort of alter your position on that framing of the issue?
I think that your decision in Hunt frames the issue in that we need to look at the nature of the expenditure that is being challenged. So, other courts have interpreted prior case law like McKee versus Likens as requiring a specific and unlawful expenditure. And when you think about that, what the expenditure of funds is the interest that a taxpayer has. I've paid money into the taxes. If they're wasted through illegal action, my taxes are going to go up and I'm going to be harmed. A taxpayer bringing a claim under the taxpayer standing doctrine is sort of like a class representative of all taxpayers. So to your question, I do believe that the case law of this court requires the existence of a specific and unlawful expenditure of funds, and there needs to be an illegality with relation to that expenditure itself. So when you look at a claim under Hunt, is it central or is it incidental? A taxpayer, in order to establish mere taxpayer standing, needs to say, this money is being spent in a manner that is illegal, and that expenditure is going to increase the tax burden, therefore I'm harmed. That is the basis that allows them to have that limited interest overcome the general rules of standings. We have a limited exception to these general rules, and the only way to make sure that the limited exception doesn't swallow the entire rule is to make sure that they remain limited and exceptional. And this court took a good step in that direction by clarifying that, merely saying illegal action, which was just dicta in prior cases, is not the standard. It needs to relate to expenditures of funds that are unlawful in and of themselves. And that's not the only, key limiting principle that decisions of this court have put in place with respect to the taxpayer standing doctrine. So not only does you need to have a specific and unlawful disbursement, it needs to involve unlawful expenditures that increase their state and local tax burden. That's the taxpayer's interest. That's their injury. If there's a case that involves tax cuts or credits, like the Olson versus State case, this court held that that doesn't increase the tax burden. They're not asserting that there is an unlawful action that increases it.
Counsel, is there anything in the record that ties the expenditures of the tax dollars directly to what seems to me to be a policy decision?
There's nothing in the record that directly ties that. There are allegations that money will be spent. And there's a statement in the brief, in plaintiff's brief before this court, which I say in all fairness, the plaintiff did not have Hunt when they briefed it. I did not have Hunt when I briefed it. The Court of Appeals did not have Hunt when they decided this case. The Ms. Clapp's brief says that she simply needs to allege that money is being spent, and we know now under Hunt that that is not sufficient because—
But counsel, isn't it true that actually in the complaint, they're more specific about how that funding is being designated? Teacher salaries, expenses associated with the process of laying off. Also implementing the contract, including reassignments, reinstating, retaining teachers, in furtherance of and to ensure compliance with Article 15. That will cost defendants public money. There's a whole list of things in the complaint, isn't there?
There are a list of things that are in the complaint, but what is notable about the list of expenditures in the complaint is that none of those expenditures are illegal. So when we're looking at what the taxpayer is trying to stop, it would to stop illegal spending of funds. The school district is required under PELRA to meet and negotiate with its exclusive representative. It's required to spend money negotiating a contract with its unionized employees. It is specifically required under the education code to negotiate with the teachers union regarding layoff provisions. They must negotiate a plan for unrequested leave of absence. Minneapolis Public Schools has not exceeded any of its powers in negotiating, implementing this contract. The respondents' disagreement with the language is not about money, it is about policy. We would spend the same funds to implement a layoff provision that we're legally required to negotiate if it was a different policy that was represented by the nature of the contract. But this contract represents the agreement between the largest school board in the state of Minnesota and a teachers union that represents 2,000 public employees. This contract was negotiated to end a 3-week strike of Minneapolis public schools. What we have here is we don't have a teacher that is disagreeing with the contract. We have somebody who is not involved in the contract process at all. And this is where the amici are noteworthy in this case. We have public unions that have said that the Court of Appeals decision in this case needs to be reversed or it'll be bad policy. We have public employers that have stated that. We have the School Boards Association that point out that the public policy under PELRA is for the orderly negotiation and promotion of labor peace to the extent possible, and permitting a non-party to the contract to insert themselves, particularly when their complaint is not centrally related to unlawful expenditure of funds, is a bridge too far.
So if we were, just take for a moment, and we were inclined to agree with the other side that this provision might be unconstitutional, who would have standing to challenge this provision?
So if the language were to be utilized in a manner that a teacher believed that they were being discriminated against on the basis of a protected characteristic, that teacher would have standing to challenge the application of the language upon them.
And in your view of the case, or in the case law, is there any circumstance where a taxpayer would have standing to challenge a provision of a collective bargaining agreement?
That's a good question. If there were a provision of a contract that's centrally related to an expenditure of funds that was unlawful in a particular manner, for example, if there was a payment to specifically negotiated payment that was on its face arguably illegal, then the central thrust of the claims would be this money is being spent in an illegal manner. Essentially what they're saying is, I think that the language here isn't going to hold up in court someday, therefore it's illegal, and because they're going to spend money on it, I can use that as a foothold to get in the door. I think that's what this court was trying to prevent in Hunt, when they say, you cannot manufacture standing that otherwise doesn't exist by merely pointing to some money that is being spent. That seems closer to the old interpretation of some of the cases that has been clarified, where taxpayers arguably could have had standing to challenge illegal action, and that is just not the law anymore. It wasn't the law before, but it certainly is not post-Hunt.
Counsel, maybe you've touched on this in your answer, but I had a similar concern to Justice Procaccini's, because it does seem like you're almost arguing that there's a class of cases, in this instance, cases where there's a collective bargaining agreement. I mean, that you're right, that's the thrust of almost all of the amicus briefs that we have, that because this is governed by PELRA, that there's this class of cases where almost by definition you cannot have taxpayer standing. And I don't think we've ever said that. Why, am I wrong to be concerned about that, or is that not a concern, or tell me your thoughts about that?
I don't think it would be wrong for this court to delineate classifications of cases that taxpayer standing simply does not apply to. The category of cases under Hunt would be those of which the claim is incidental rather than central. And I think that the focus when you're applying Hunt, or when courts are applying Hunt in the future, when you're looking at
but that's not really a class of cases. That's kind of a, I'm not sure what that is. That's a descriptor. But I mean, there's PELRA. You know what I mean? Though that is a particular subset of the law, and it almost feels like you're saying there are subsets of the law where taxpayer standing does not apply. And I don't think we've ever said that.
I don't think you've ever said that, and I don't want to put words into your mouth. The way that I see and the way that I interpret the cases involving taxpayer standing, both in this state and in other states, because we're not the only case that has the common law concept of taxpayer standing. When you look at the nature of a taxpayer's interest, their interest is to prevent their tax dollars from being depleted because they're being spent illegally.
Arguing that no PELRA case could ever, is that your argument, that no case that involves collective bargaining could ever be subject to taxpayer standing? I thought you just said that, Justice Procaccini, that if a actual provision was illegal, that could be challenged.
I'm not arguing that there is not a potential case, that might arise involving a collective bargaining agreement under PELRA, where an expenditure itself is central to the dispute.
And we wouldn't have to say that for you to prevail, that carve out PELRA completely.
Oh, no, Your Honor. In order for Minneapolis Public Schools in this case to prevail, this court would just need to determine that merely alleging that some money is going to be spent in the negotiation of this contract that otherwise would be spent if there was a different provision that Ms. Clapp didn't agree with, that therefore any spending that is being alleged in this case is just incidental to the claims, not central to the claims. I mean, what we look in the complaint, we know what Ms. Clapp is asserting. It's interesting what she's not asserting. She's not asserting that the school district cannot lay off employees. She's not asserting that the school district cannot engage in collective bargaining.
Is there any money that is involved in rejiggering the system, or that probably money that's spent already at this point to rejigger the computer system or whatever, to be able to figure out? And before, you didn't have to consider certain factors. Now you have to consider certain factors.
I would say that the language is may. It is permissive, not shall. So just, while we're not talking about the merits of the language in itself, nothing on the face of the language requires the school district to engage in that. But as far as the expenditures or what would be used, the reality is that government expends public funds to exist. It hires employees, it pays them a wage, it has overhead in the building that it rents, it has computers that it loans or leases.
I agree with all that. I'm just asking specifically to this provision. Was there money spent to change the system?
No.
Okay.
No, Your Honor. I mean, this is the stage of this case. I would say that the brief submitted by Education Minnesota and the Minneapolis Federation of Teachers does a really good job of explaining the collective bargaining process and explaining the accessing process, for example. And they also notably pointed out in that case that Minneapolis Public Schools hasn't laid off a teacher since 2010.
The respondent suggests that maybe we should remand this case back for some jurisdictional discovery. What do you think we'd learn if there was such a remand?
I would say, Your Honor, to that question, the jurisdictional discovery doesn't change the nature of the allegations. When we look at the complaint and he's saying these expenditures are happening and the language that they're spending money on is illegality. The illegality that they're pointing to has nothing to do with the money. The illegality they're pointing to has nothing to do with the expenditure of funds. They're saying that money is being spent on a contract provision that I disagree with and I believe is illegal. Therefore, that money is not being spent legally. That's putting the cart before the horse. The focus on whether it's central or incidental to the claim it cannot be on the perspective of the plaintiff, or plaintiffs are just going to try to plead their way around Hunt by saying my central dispute here is the expenditure of funds.
So if we had a contract in front of us that said that a certain class of teachers would be paid more based on their belonging to a particular class, would that be a different case because then we would have a specific expenditure of money?
I think that would be, the classic statement is that you change the facts, you change the case. And I think that is a very interesting example to bring up where you would have contract language that is monetary. There is spending that is implied by it. And if you were paying people a different amount of money based upon a protected characteristic, then I could see a more facially acceptable claim that there was a appropriation or expenditure of public funds in a manner that was illegal.
But in that scenario, I heard you arguing earlier that we also need to find that somehow it would have an overall tax impact on the plaintiff. And in that scenario, I guess I'm giving you a hypothetical on the spot here. But if the contract weren't to spend more money, I think would your position still be that there wasn't enough for taxpayer standing, even if there were a differential pay provision?
That is an intriguing question as well. The cases have said that the whole basis of the taxpayer's injury, the reason they might get in there is to protect the tax base, to protect so to the extent that more new money was, there was an increase in the expenditure of funds that was, it's still tenuous in my opinion, because when you think, what percentage of the tax dollars go towards, funding the school, and it's hard to actually trace those dollars. But the idea being focus on the nature of the taxpayer, because ultimately anybody to have standing in any court, they have to have suffered an injury. We just recognize that taxpayers could suffer an injury. So in your circumstance, I think that they could make a better argument towards some of the limiting principles that this court has implied, but they still might have a hard time due to how much is it really going to be increasing the tax base. Ultimately, the checks and balances of, the separation of powers, it's not appropriate for the courts to control the policy-making decisions of the executive and legislative branches in the absence of an appropriate case that's brought within the jurisdiction of the court. The appropriate way for policy to be established, which includes spending and direction and how to handle layoffs and any other contract provision, would be to handle at the ballot box with the elected officials.
Well, and I think, as I understand your previous answers to my questions, if one of the teachers in the class that was getting paid less, it seems to me that you're conceding pretty clearly would have standing in that situation to bring a claim on their own accord and have their own specific injury.
Barring any uniqueness of whether they have to pursue a grievance through the provisions of the contract, then we're looking at a particularized injury in fact that a person, all of a sudden, that's what a plaintiff is supposed to look like in the courts. As in my introduction, I talked about courts aren't designed to handle, these philosophical disputes. We want to handle actual disputes that are ripe, that it's the right people bringing the claim at the right time.
Counsel, along those lines, I'd like to ask you about the mootness issue here. that supplemental briefing was done on. Your position is this case is moot and there's no exceptions that apply to resurrect it. And so two-part question. First of all, why isn't the respondent correct here that one of the exceptions to the mootness doctrine should apply here, given the cyclical nature of collective bargaining agreements, question of repetition yet evading review, or the second question about statewide importance and something being functionally justiciable? And then I guess a corollary question is, if we agree with you on mootness, then what happens to the Court of Appeals published opinion on this issue?
Well, Your Honor, our position on mootness is that the party who's seeking to benefit from an exception bears the burden of establishing that exception. So, we do concede that the language is still in the contract, but, facially moot would be the remedy that they're seeking is to stop spending on money towards a contract that's now expired. As far as, if they were to move to amend their complaint, back at the district court, I know that is allowed as justice freely requires, but we would oppose that on the notion that it is futile because she doesn't have standing. It always comes back to standing. But to your question, if you were to find that this decision was moot without overturning the Court of Appeals decision, I still think that the Court of Appeals decision would have some sort of a flag next to it if you were looking on Westlaw because of this court's decision in Hunt. It decided the same issues that shortly were clarified by the highest court in this state, and that decision is not consistent. I do not believe that decision would be the same if they had the benefit of Hunt while we were analyzing the expenditures in the case. And I think that the Rule 12 liberal pleading standard is another interesting issue that needs to be addressed in this case. It is true that we're a notice pleading state, but illegal conclusions are not binding, and they must provide more than labels and legal conclusions. When you look at the allegations in the case here, we know that, in her brief, she says all she needs to do is allege that money is being spent, and we know that isn't accurate anymore. But the main point is that you need to make your allegations in a manner that doesn't rely on the court giving deference to legal conclusions. Your allegations about unlawful disbursements, you better allege a disbursement in such a manner that it is the disbursement itself that is illegal, and that your dispute is about the money. I am concerned that my money is being spent in a manner that is illegal. Not they're doing something illegal and they're spending money to do it, therefore I get to be the one who brings this case. In the Hunt, they talked about, in that case, there was actual legislative appropriations. There was tens of thousands of dollars that was appropriated for the purpose of educating the public on the change in the law. But this court recognized that, the statute was intended to focus on restoring certain individuals' right to vote. The thrust of the complaint was that that statute is unconstitutional in the manner that it went about. The only reason that the spending of funds was raised was to manufacture standing where it otherwise did not exist. And if you replace, the word law or the word statute with contract, and you think about this case, she's not concerned that money is being spent to change the way that the parties are considering layoffs. Ms. Clapp doesn't like the way that the parties are considering layoffs, and the only reason money is being brought up is to get in court. So that's, we focus on the nature of the claimed expenditures, not, that whether it's central or not. And I think that, the cases that we've cited from other states are persuasive in that this isn't the only state that's dealt with general operating expenses. Government spends money. The district court in Hunt pointed out, I don't see how we can expand the taxpayer standing in this manner without blowing the door wide open, because government is going to spend money. There are the salaries of people working. There's paper that is printed off. There was an unpublished decision that I cited in my brief that involved the Minnesota Department of Natural Resources. It was called Center for Biological Diversity versus Minnesota DNR. Obviously unpublished, obviously Court of Appeals, but I think that it's very persuasive and analogous. Their taxpayers didn't like the fact that wolf hunting had been made legal. The DNR promulgated rules related to wolf hunting. They printed out wolf booklets. They were selling wolf licenses. They argued that those rules involved the use of money. They printed the hunting regulation booklets. They established electronic licensing. They had to rejigger their system for a new rule, as you brought up, Your Honor. Okay. The court rejected this, but the DNR routinely permits electronic licensing and annually publishes booklets to educate the public about hunting regulations. Petitioners do not contend these expenditures would have been avoided had the DNR promulgated different rules or used a different rulemaking process. Because the expenditures associated with the Wolf rules do not increase the overall tax burden, they're not expenditures for the purpose of establishing taxpayer standing. And that's any type of general operating expenses that are going to be spent. You brought up, is not new money going to be spent to change the system and how we determine? It would be. We could change any number of ways to determine layoffs. This is just one way of doing it that was negotiated between the parties to this contract, the ones that were elected by the same taxpayers of the city of Minneapolis to represent them on the school board, and by who the teachers elected to represent them as a union. And I think that that's where the concern comes in about the number of contracts that governmental entities enter into in general, being open to taxpayer challenges. So when we look at it's not that there's not a remedy if there is a truly unlawful expenditure of funds. When you look at the old cases, if you have a municipal bidding issue, if you have an employee who's hired in a manner that doesn't follow the civil service rules, that is, they're spending money on a person and they didn't do it in the right way. Even McKee versus Likens, it really wasn't about abortion. It was about the rulemaking process for spending funds in a particular way. And in this case, they were challenging the manner in which the money was being spent. It was a central dispute about the expenditure of funds, not just relying on money being spent to get in the door.
Tell us a little bit about ripeness. Do you agree with the Court of Appeals that if we disagree with you on standing, that the case is ripe because the harm is ongoing?
So ripeness is a justiciability issue that needs to be determined, and I think that ripeness in a taxpayer case I've been fascinated learning more about this, trying to weigh out standing versus ripeness. So under the Declaratory Judgments Act, a person whose rights, status, or legal relations are affected by a statute, law, contract, they can get a declaration of their rights. In this case, we have to think about what are Ms. Clapp's rights? What are her interests under this contract? She's not a party to the contract. She's not at risk of being laid off. Nobody is. The unions, the Education Minnesota's amicus brief that they submitted talked about the ripeness, and I felt in a pretty interesting manner talking about even the union doesn't believe that anybody that would have standing has a ripe claim. So a DEC action is only ripe if the complaining party is possessed of a judicially protectable right or interest which is in place in jeopardy by a ripe or ripening seeds of an actual controversy. So in order for it to be ripe, she has to allege that her interest as a taxpayer is in jeopardy of being attacked right now. That actually kind of feeds back into standing, where there is no threat to her interest as a taxpayer right now.
But assume we're siding with Ms. Clapp on that and saying that the spending that she's identified does meet the MVA standard. If we get there, it feels to me like at that point, then her claim is ripe because she's alleged that there's ongoing spending related to implementing these policies. Is that off?
I think that if you look at this court's decision from earlier this year in the Grohl versus Simon case, where they were looking at the presidential election and whether or not a particular candidate should be on the ballot, they were looking at the primary election and they were looking at the general election, and they found there was no question that that candidate was going to appear on the ballot as a candidate for the GOP primary, but it was too far remote in 6 months between February when it was decided and August, the end of the nomination process, to determine whether we know that that particular individual was going to be on the ballot. The court said that a lot can happen between, history shows us that a lot can happen between now and the nominating conventions. So my position would be is if it was not ripe whether or not Donald Trump was going to be the Republican nominee in the general election due to the 6 month of intervening process, what we have in this case is this lawsuit was initiated quite some time ago and there hasn't been any layoffs. Education Minnesota's amicus brief says that there has not been a layoff of a Minneapolis teacher in 14 years since 2010. The way, if you look at the contract as a whole, all of the probationary employees, all of the Tier 1 and Tier 2 teachers, they need to be let go before any tenured teachers are laid off. And the number of those non-tenured teachers that have been employed by the district, that actually provides quite a buffer for the tenured teachers when it comes to cuts. So Minneapolis and the union, through their negotiated process, have been able to avoid laying off employees for 14 years. And yet, the idea that merely alleging that I believe that that cuts are going to happen in the future, and that to me doesn't feel like her rights are in imminent need because they need protection from an attack emanating from a source competent legally to place such legal interest or right in jeopardy. And again, the only legal interest or right that she has in this case is her right as a taxpayer to not have her tax funds spent in an illegal manner. So what is the nature of her interest? That is a taxpayer. Is this interest in need of protection from an imminent threat? How are taxpayers of the city of the Minneapolis School District in need of protection from an imminent threat due to duly negotiated contract language that has not been applied, and even its prior language hasn't been applied in 14 years?
But counsel, we're talking about notice pleading, right? We're not talking about the fact that perhaps no one's been laid off for years and years and years. We're talking about what was pled in the complaint in this case, and which kind of brings us back to standing. Mm-hmm. And we've got a plaintiff who is claiming that the policy violates equal protection, so that would be the illegality being claimed, pleads that the policy will result in the taxpayer money being diverted down a certain path based on that policy in the event of layoffs, right? That's the claim. Isn't that the bare minimum that you need in a notice pleading state?
That would not be the bare minimum because notice pleading doesn't excuse legal deficiencies. And under Hunt, the central issue of the case needs to be the unlawful expenditure of the funds. In your question, the allegation is that this policy is illegal. There's a number of cases in Minnesota that say that mere disagreements on policy are not sufficient to open the door to taxpayers on standing. The raising of every policy that the government enacts uses some sort of public funds, or almost all. So if that's all that is needed, then there is virtually no limit to when a taxpayer can challenge any policy that they disagree with no personal stake or injury in it, just merely based upon the fact that I paid my taxes, therefore I am entitled to intervene on this.
Counsel, given the number of amici in this case and some of the points that you've made, doesn't the public interest, or wouldn't the public interest be better served by us not finding this case moot and just addressing these issues head on?
I think that the clarification of when we petitioned this court for review of the Court of Appeals decision, it was for the reasons that we set forth in the petition, that if left to stand, the Court of Appeals decision in this case is an incorrect description of the law, and it is going to encourage cases that should not be open to standing in this court. So I would agree with you that it is in the best interest of the public to have clarification of what is required at the complaint stage to meet consistent with Hunt, consistent with this court's prior case law. Our position is that the expenditure needs to be center, it needs to be the star of the show, and the illegality needs to be related to that expenditure of funds in a manner that's going to actually harm the taxpayer by raising their taxes.
Counsel,
I see I'm out of time, so
yes.
I will thank you, Your Honor.
Your time has expired. Thank you. You'll have 3 minutes for rebuttal. Mr. Bashika?
Bekesha, Your Honor.
Bekesha, I almost had it right. Thank you.
Thank you. Good morning. May it please the court. Michael Bekesha on behalf of plaintiff respondent Deborah Clapp. We're here today, actually let me just clarify, we're here today solely on count 1. Count 2 we know is no longer a viable claim after this court's most recent decision in Minnesota Voter Alliance. So we're here on count 1 only. Ms. Clapp challenges Article 15 of the negotiated contract. Article 15 states, which is reproduced in part in the appellant's appendix, pages 23 and 24, which was the appellate court ruling. The school district shall excise the next least senior teacher who is not a member of an underrepresented population. The school shall deprioritize the more senior teacher who is not a member of an underrepresented population. Ms. Clapp is challenging the expenditures that will be made and are being made to undertake the excising of the least senior teacher based on certain races and ethnicities, and the deprioritization of more senior teachers based on race, certain races and ethnicity. And so the central focus of her claim and what the appellate court found is the process by which the teachers are going to be excised or reassigned, or as one of the union leaders stated, laid off in this process. The idea that these are just incidental is not the same as in Hunt. In Hunt, this court said that the central focus of that claim was the restoration of rights. The restoration of voting rights doesn't take any expenditure whatsoever. The rights are just restored. It was what came after the rights that were restored that the taxpayers in that case were challenging. Here, what we're challenging is the negotiated term of the contract, which was a process by which Minneapolis Public Schools is making hiring, firing, employment decisions of their teachers based on race or ethnicity. And so the focus is, it could be the rejiggering of the computer systems. It could be the HR, the salary of the HR individual. It could be lists that are created. It's other steps that are needed so that Minneapolis Public Schools can classify their teachers by race and ethnicity. And in the end, you have an expenditure, which you have a teacher that but for this discriminatory process would not have a job. And so we're not saying that, having a teacher of a certain race is illegal or is the illegal expenditure. It's the nature of how we get there. It's very similar to the other cases that this court has heard over the years and to an extent reaffirmed or cited to in its most recent taxpayer case.
Counsel, I'm going to stop you to see if the court has any questions. Your 3 minutes have expired.
Counsel, the amici make sort of a broad policy argument, I think, to a degree regarding the potential implications of a ruling in your client's favor in this case. And I guess I'm curious about what your response is to the concern that giving taxpayers standing to challenge collective bargaining agreements between school districts and teachers really could fundamentally interfere with the purpose of PELRA, to encourage resolution of labor disputes between public employees and their employers. I guess the difficulties with public schools and negotiations, I guess, worry about a lot of potential second guessing of policy decisions coming through, taxpayer litigation. What is your response to that overarching concern?
When you have taxpayer cases, the government always wants to narrow and limit taxpayer standing as much as possible because the government doesn't want to be checked. Here, the unions don't want to be checked. They don't want a taxpayer to be able to come in and not challenge a policy disagreement. That's not what we have here. We have an unconstitutional provision. And so my response to that is, this court has always said that diverting of any funds towards an illegal expenditure is problematic and can be addressed.
Well, if I could just gently push back on you a little bit about the rejection of the notion that this is a policy dispute. Isn't this contractual provision required by state law to be part of a collective bargaining agreement?
State law requires a collective bargaining agreement. It agrees the unions and the school district to come together. It doesn't require them to have this process to lay off teachers. It doesn't require unconstitutional action.
Well,
If
I could just interject, of course it doesn't require unconstitutional action, but section 122A.41, subdivision 14A requires the school board and the exclusive bargaining units to negotiate a plan for providing for unrequested leaves of absence. I mean, it seems like, isn't that the underlying legal requirement that the school district is trying to respond to and negotiating with the teachers on this question?
Yes, Your Honor, but if the school district entered into a policy, part of the requirement is to pay teachers, to reach an agreement where teachers are paid. If the school district and the unions entered into an agreement that said all white teachers must work for free, all black teachers get paid X number of dollars, or we will only hire teachers of a certain race, or that we will only teach students of a certain color, or that we'll provide textbooks only to students of a certain color, that would be fulfilling their statutory obligation to meet and confer and negotiate bargain terms. That doesn't mean that what they can do is negotiate for terms that would violate the Minnesota Constitution. And so there are limitations. It is the policy limitations, but it is not the limitations that we're challenging here. We're challenging specifically the process by which teachers employment decisions are being made by teachers. The expenditures that go towards those employment decisions are the expenditures we're challenging. Those are directly related to what we're challenging. And then in the end, what you have is you have the salaries for those teachers, but for this method, but for this process that is discriminatory, wouldn't be paid. And so these cases are very similar to the cases that we cite in our brief. And
Mr. Bekesha, if I could stop you, do you agree with Mr. Sullivan's claim that he told us that they would be spending the same monies even if it was some different policy? Do you agree or disagree with that? And does it make any difference to your argument?
We don't know if they'd be spending exactly the same money or not. If, for example, the rejiggering of the computer system, that may be an additional expense. However, in our view, based on the case law of this court, that does not matter. If you look at cases going back to Grannis about the city buying a truck, the issue there was not whether or not there was a purchase of a truck, but whether or not the mayor signed off on that expenditure. And so even if the mayor had signed off, the truck would have been bought. So the same money would have been spent. Similarly, Sinclair with advertising or putting in a newspaper the list of delinquent taxpayers, the issue there was that the taxpayers didn't believe what was being advertised in was a newspaper. So the challenge wasn't the amount of money that was being spent, it was that the money was being spent in a particular process or in a particular way.
It seems that if we agree with you that it would be a very broad ruling, and I'm trying to think of a circumstance where then a taxpayer wouldn't have standing to intervene in such a proceeding. So help me narrow that a little bit of what that would look like post-decision.
Post-decision, I believe it would look like the same it's looked for the past 150 years, Your Honor. We're not asking this court to do anything new or to change the law. We're just asking the court to reaffirm its decisions going back approximately 150 years.
But it seems like it is that anytime a taxpayer is opposed to a policy, such as what seems to be a policy or process decision made by the school district along with the unions, that then you would have automatic standing to object, just alleging that there has been some form of an expenditure. It just seems too tenuous to me.
With all due respect, Your Honor, one, we're not alleging a policy disagreement. We're alleging an illegal action, an illegal expenditure. And so at first, if a taxpayer has a policy disagreement, that case is easily dismissed because there's no allegation of illegality. Here we laid out an allegation of illegality.
But counsel, I mean, you just spent the first 5 or 10 minutes of your argument, like the examples you were giving us. Well, if the school district was only going to teach, Hispanic students, but not black students. I mean, you went through this whole list of things. Those seem like very fundamental policy sorts of issues. And it seems to me that is your main concern. And I guess where I'm getting at, and I think it's a valid concern. But it does seem to me that that's a policy issue, and that's the very thing that we said in our recent decision in Hunt, that doesn't get you there for taxpayer standing, because the monies that you're talking about here, it seems to me, much like in Hunt, are really incidental to the fundamental policy difference that you have with the school district. Why am I wrong about that? Why is this not incidental?
It's not incidental because we're challenging the specific, the issue here is not the hiring or firing of a specific. We're not challenging the teacher, the employment decision on the teacher. We're challenging how the school district gets there. And it's the process by which the school district gets there, where the expenditure, where the illegality is.
How is that different than Hunt when they said we're not challenging the change in the law regarding who can vote. We're challenging the money being spent to educate people about who can vote.
Because
how's it different?
Because in that case, the money being spent was on educating the individuals. That is not illegal. What they claimed was illegal, what they actually were challenging, was the restoration of the vote by the legislature, by the law, the flipping of the switch, the moving from one column to another column. That's what they were challenging, and then they found expenditures that were related to that challenge. Here, what we are challenging is Article 15. It is the shall excise teachers based on certain races and ethnicities. It is the reassigning based on certain races and ethnicities.
I'm still not seeing the difference.
So ultimately your question is, your challenge is that they're going to spend money on, well, I guess there's two things. It's not, so your challenge is not that they're going to excise an unprotected teacher instead of a protected class teacher. That's not what the basis of your claim is. It's that they're going to spend money to get to the point where they can.
And they will then spend money on that teacher that they wouldn't otherwise have been spending money on.
So is it both things?
It's both things.
It seems like the second thing is more like Hunt. Maybe the first thing is not.
I think it's a process, and in our complaint, and we've always focused on the process as the entirety that begins with the contract, the steps that are needed to be taken.
But you think you have taxpayer standing, setting aside the process to get there. It sounds like you also think you have taxpayer standing because they're going to pay a salary of someone who should not otherwise been excised except for the unconstitutional act.
That's correct, Your Honor.
Even though we're spending the same amount of money on those teachers.
Yes, Your Honor.
How is that consistent with?
Sure. I mean, I think there are two things about, counsel kept referring to that it needs to increase the tax burden. I would note that appellants did not raise that argument until the reply brief. All the cases they cite were cited for the first time on the reply brief about whether or not you need an increased tax burden. Even the case that counsel read from today was cited for the first time on reply. With that out of the way, this court in Minnesota Voters Alliance cited to Reagan in its opinion, and cited specifically to the line about honest expenditures of taxpayer funds. The focus in that case was not about whether a tax burden would increase, but whether public officials were honestly expending taxpayer funds. And the question I have for my colleague is what's changed that they believe that taxpayers no longer should have an interest in the honest expenditure of taxpayer funds. These cases have also talked, I believe it was in ARPIN, talked about the diversion of funds. So that didn't talk about the increased tax burden, but the idea that money's being diverted from one place to another, and the diversion is because is on something that is illegal.
So just getting to the underlying reasons why we have taxpayer standing, it seems to me that one of the goals is to allow taxpayers to stand in when there isn't an obvious plaintiff in a case. But here, well, let me start with, would you concede that you'd have an easier argument here if you represented a teacher who was not in one of the underrepresented groups covered by the contract?
We'd have a different case. And probably standing would be less of a challenge for the court. So would I have an easier time? I don't know. I enjoy taxpayer standing. It's more fun when it's a challenge and, we're talking about the issues. But I would say that taxpayer standing, going to the heart of your question, taxpayer standing has never been, whether in Minnesota or anywhere else in the country, you only have taxpayer standing if somebody else doesn't have a claim. And so that would be new for this court. It would be new, I believe, in all of the states that recognize taxpayer standing, because there are a few states that don't. It is just another type of case that can be brought when the government is acting illegally.
But this is a case where there's a pretty obvious class of individuals who would be plaintiffs, who would have standing under a more traditional sense of standing.
That's correct. There is, but our position and what the law has never said, if somebody has an obvious or there is a more standard type of class of people that would have standing, that taxpayer standing doesn't exist. I think that would, on a policy side, would not necessarily, taxpayers pay money to the government. They pay money so that the government can honestly expend their funds. They may have policy disputes, and that's what, as counsel said, elections are for. But here we're not just talking about a policy dispute. We're talking about unlawful action. And so, yes, a teacher that was laid off under this process would have standing, but my client also has standing as a taxpayer.
And just to return to the Chief's line of questioning and Justice Thiessen's too, it seemed to me in Hunt, the government conceded that there were sort of two things. There were some costs of implementation, the sort of rejiggering of the system to recognize new voters. And there was also some statutory spending to educate folks about the change. And so I'm still struggling to see just what that differentiation is here, where the district is saying, sure, if we do layoffs, there's some, spending that's associated with doing those layoffs and implementing the policy, but it's no more than we would if we had a different layoff policy, right?
In that case, the challenge was not on that the process of rejiggering was unlawful or unconstitutional. In that case, the sole challenge, the illegality, was the restoration of the right to vote. It was a right. We're not challenging a right here. We're not challenging a right or a status. What we're challenging is the process. And so the process that we're challenging is the manner by which employment decisions are being made based on certain races and ethnicity. And so it's more of a direct...
But counsel, we tried to make clear in Hunt that it isn't enough to show illegal action on the part of a public official. What you've got to show is that the expenditures themselves are illegal. And I'm not sure so how does your argument fit within that? The expenditures are going towards the school district separating teachers out by race. It is going to making decisions based on race. The Minnesota Equal Protection Guarantee prohibits the government from making decisions, from taking actions exclusively, only based on race.
So how isn't that, whose rights are being invaded there? I mean, you make this, I'm coming back to this distinction, you say Hunt was about a challenge to a right as opposed to something else. Here isn't it the right of the teacher in the unprotected group to not be laid off instead of another teacher? I mean, it seems like this is actually about an individual right as well. I don't get that distinction.
Sure, it's, to an extent, yes. But the focus there, I guess, was
I mean, I get
no money, sorry, Your Honor.
No, go ahead.
No money, when the law passed and the rights were restored, right? No money had to be spent at all for the rights to be restored, because the law did it. Here, if Minneapolis Public Schools doesn't do anything, there's no right for that teacher.
No one's right would be invaded.
No one's right would be invaded. So the rights are being invaded solely because they have agreed, they have contracted. One of the terms of the agreement, consideration, one of the terms was that they would undergo a process prioritizing certain races and ethnicities over others. And so the violation is that agreement to undertake a process. It's not, without the process, there is no violation.
So it's not the spending the money on the process necessarily, although some money will have to be spent, but it's the spending of that money following an illegal process that is at the heart of your claim.
It's a spending the money on the illegal process, because the illegal process, there is no process without money.
But why isn't that in turn then incidental to the process? That's what Hunt is all about.
Right, because there is no process without money. There's no HR person, there's no list.
But that's true of every government action. That's true of literally every governmental action. There's no action without a government employee doing the thing, doing the act, right? So where is your limiting principle?
The limiting principle is, going back to Hunt, it's not incidental. It is what was contracted for. And so, I mean, if the individual, if they contracted for murdering, executing their political enemies, the contracting of that individual is not illegal. Paying somebody is not illegal. Under that thinking, what's illegal is the fact that they're hiring somebody to commit murder, which is illegal. And so the money is being spent towards an illegal purpose. And so we are very much directly challenging. We are challenging the expenditure. We're challenging the process. We're not challenging something incidental, such as educating the public after a right has already been restored.
Counsel, can I ask you, in your mind, do we need to clarify our clarification in Hunt? Do we need to say something different, or what's the syllabus point? What would you have us write? Or are you saying this is not inconsistent with Hunt, this is consistent with Hunt?
Do
we have to fit you into Hunt, or are you asking us to write something different?
This is consistent to Hunt. As the appellate court found, we allege that money is being spent on the illegal process. That is directly related to what we're challenging, and then in the end, there'll be money spent on teachers that, but for that, wouldn't be receiving that salary. And so we don't believe that Hunt is inconsistent. We believe this is consistent. We believe that incidental in Hunt was not the amount of money being spent. It wasn't nominal, it wasn't in due course, it wasn't general operating costs, whatever you want to call those different types of terms. Incidental meant what was being challenged would still exist even without the expenditure funds. The restoration of rights would still exist even if no money was ever spent. Here, nothing would exist if no money was spent on the process as a negotiated part of the contract.
But I don't know that that's quite right. The restoration of rights required some amount of governmental involvement. People needed to be registered to vote, and the election judges need to make sure that those people were able to vote. And those are all things where we have employees receiving government money to implement a new policy.
With all due respect, I see my time is out. With all due respect, Your Honor, the right to vote would still exist. The right to vote existed regardless of of what took place for that individual to vote. The right, what was challenged was not.
Although, counsel, I think what Justice Procaccini was getting at, I think in Hunt, the legislature allocated the Secretary of State like $14,000 or $15,000 to do some of the things Justice Procaccini's talking about, and then there was another $200,000 for education and all that kind of stuff. But there was money spent to reconfigure whatever the Secretary of State had to do to put that law into action.
That's correct, Your Honor. But in that case, the right would still exist. The taxpayers there didn't say that the $14,000 that was being spent to rejigger to allow those people to vote was illegal. What they were saying was the restoration of right was illegal. Where in our case, it would have been the process of getting people registered so that they can vote is what we're challenging that step before, not the right, but the agreed upon term is the school district shall excise, the school district shall reassign. We are focused on what the school district is required to do and the expenditures that are undertaking in what they're required to do. If they don't do any of that, in Hunt, if they didn't do any of that, those people still would have a right to vote. Here, if the school district doesn't excise teachers, go through the process that they have signed on to, they're in breach of contract.
Okay, thank you.
Thank you.
Rebuttal, Mr. Sullivan.
Oh, thank you.
Maybe you can
Shouldn't
pick
have
up
my
right
name.
there where Mr. Bekesha left off. I mean, what's your response to that?
So my response is that, under Hunt and prior case law, the expenditures themselves need to be illegal. It's not a matter of, asserting that they're spending money on something that's illegal. That is not what this court said in Hunt. That is incidental to, not central to.
So what is incidental? What did we mean by incidental? Is it like the proportion of money? Or did we mean it doesn't go, there's two different things in Hunt, right? There's the 14,000, which seems like not necessarily incidental, except in the sense that it's not very much money. And then it also seems like the education materials, all that was saying is educate the people on what the law the legislature passed. There's nothing illegal about that. So that's kind of incidental in a different way, right? It's like not related to the heart of the dispute. So what were we getting at do you think, in Hunt?
I think what the court was getting at in Hunt is that you look at the arguments about illegality. Why is this illegal? And if it's not related to the spending of money.
But they're saying that it is illegal to spend money to hire a teacher in a protected class instead of a teacher in an unprotected class. That is illegal in itself.
But that is not the illegality that opens the door to a taxpayer standing under Hunt. You have to, the cases that were cited, there was about the purchase of a truck, right? They're purchasing a truck, and the issue was that the mayor didn't sign off on it. That's part of the purchasing process. The purchasing process wasn't followed. They can't spend that money because
What about McKee?
In McKee, it was they didn't follow the Administrative Procedures Act. It's the equivalent of the mayor not signing off on it. You didn't follow the right process, the legal process, to spend this money. And it doesn't matter if you're spending it on something legal in that, whether it's a truck, whether it's something else, whether you're bidding on a construction contract without following the municipal bidding law. You only can spend money in this way. And it's about the spending of money. And I think that's the difference between the expenditures themselves being illegal. That process is not the same question of spending money towards something that a person disagrees with on the basis of it being illegal. The Missouri cases that I cited in the brief, they kind of break it down with direct expenditures versus indirect expenditures. It might be a good way to sort of conceptualize this. In the cases where taxpayers have standing, it's where there's a direct expenditure that is illegal, whereas, there's always an incidental expenditure. There's always a non-direct expenditure. Another thing, even in Hunt, the reviser of statutes has to spend money publishing and codifying the statutes too. That's additional money that's spent. That isn't what the taxpayer standing doctrine is looking at for illegal use of money. There has to be something on, and then briefly, I just want to address the notion that arguments were raised in a reply brief versus the direct brief, to point out that the reply brief was in response to Ms. Clapp's claim that all she has to allege is that money is being spent, and we pointed out the number of limiting principles that this court and the Court of Appeals have applied to the taxpayer standing doctrine over the years. So I see that my time is up. I thank you for your time this morning.
Thank you, counsel. Thank you both for the help that you provided to the court. The matter is deemed submitted, and we will make our decision in due course.